structured society that matters and affects your stewardship as a follower of Jesus. And you'll hear me say it in a second with our friends here. They're on the end of it that deals with it. And this is one of those bizarre intersections as a pastor you don't really realize you're going to have regularly as a pastor. I'm on the intersection of this as well, and I see the difficulty and frustration and sometimes the hurt or sometimes the lack of ability for loved ones to care for them when these things happen or aren't addressed. So that said, we're going to go into our little bit of a Q&A. Let me grab, you got a mic? Awesome, okay. So first off, Miss Patty, feel free, say maybe anything about yourself. I didn't say just in brief there, give yourself a short introduction, and we'll go over to you, Attorney Faulkner, for the same way. So just let everyone know anything that we didn't say clearly.
Okay. I think the biggest thing I'd like to say is that a lot of my experience came from real life. And it actually, when I was talking to Pastor Paul beforehand, I was talking about the fact that when I was 30 years old and I lost my dad, that is what made me realize how important it was to have documents in place. And my mother relied heavily on me, and I think she ended up being one of my best teachers to doing things. So, and at the time, it was John's father-in-law that took care of both of my parents' stuff. So it's so important. And the only thing other thing I'll say is, as far as end-of-life planning goes, the best gift that my mom gave to all of our siblings is she did all of her planning. So when she passed, we didn't have to wonder where Mom wanted to be buried, her coffin, anything. All of it was taken care of. So it was a huge relief to have all of that taken care of prior to, or after she passed. But we didn't have to take care of it because she did.
Right. Attorney Faulkner?
So my name's John Faulkner. I live about 2 minutes down the road here in Beaver Creek. I grew up in this area. I have been practicing law for 20 years. My office is also just down the street on Harbert Drive, across from like River Valley and Speedway and all that. Went to Dayton Christian High School, graduated from Cedarville College, and then University of Dayton Law School. In my practice, I'm what's known as an Ohio State Bar Association certified specialist in estate planning, trust, and probate law. As a probate attorney, people are always like, what kind of attorney are you? They want something exciting, like I go to court and people keep them out of jail and all that stuff. Actually, I think my practice is more exciting than that. I get to really help people. As an attorney, I can tell you I really don't like most attorneys because of all the reasons that you already know. Matter of fact, I think we've confirmed one thing today. Here I am, a lawyer, sitting at a church, and the roof didn't collapse, and the walls are still up, so that's good.
That's right.
I don't know if the curtain split behind us, but
Good.
But no, in all seriousness, my practice, I've been practicing for 20 years. We're a small office. I worked for a long time with my father-in-law. He retired after 46 years of being a lawyer, and a lot of it is just our family business, helping families. Someone is in a rough spot. I don't know everything, but I know how to help people navigate difficult times when it comes to property issues, hospital issues, competency issues, elder law, nursing homes. These are big events in life, causes a lot of stress. I have the blessing of being able to help people through those stressful times. And Patty has said it, and Pastor Paul said it too. It's the best thing you can do is stewardship. Be proactive. When you're proactive, I think you are honoring the instruction in Scripture to be a steward. If you put it off, I can tell you it's going to be a feeling of helplessness, nervousness. You miss something, it's stressful for you, your family. So I understand it's not fun to talk about death, dying, and disability. I also understand that when you're young, it's easy to say, this will never apply to me. I could bore you guys with stories all day long about people at the age of 18 unexpectedly having a medical event or death. People who are 99 years old who say, I've never had a will before, John. I've never needed it before. Well, I think, and Pastor Paul, you're the scriptural expert, but I think only 2 people made it off the planet Earth alive, right?
Yeah.
One was an Old Testament king and one was Jesus. The rest of us, the odds are not in our favor. So proper planning is going to help you and your family. So that's my encouragement for the start of the year. Make it a goal.
Yeah. I appreciate you both doing that. So let's start with the obvious then. In both of your all's experience, what keeps people from doing this? I get that's a wide-ranging question, but what's been some items or trends you see? What keeps people, no matter their age, what keeps people from doing this?
I'll do the easy one because John knows all the answers. One thing is people think it's going to cost a lot, and in fact, it doesn't really cost as much to get the documents in place as what it'll cost by not having the documents in place. And then my second one will be just life gets in the way. And unfortunately, this is something that you have to prioritize, so you have to make it happen.
Yeah, I agree. I think the fear of what it will cost you is probably the biggest hurdle. I can tell you, I've dealt with legal Zoom documents. People ask, are those legal? They're legal. They may or may not be cheaper than working with a real lawyer. In my practice, a will might cost a couple $100. I can tell you, legal Zoom, when you go through and fill out all the stuff and then you have to push the pay now button, it's about the same price. The difference is I've got malpractice insurance and a law license that says I did it right. LegalZoom is you doing it. I'm not making fun, but in the United States, you can sell your own house, you can do your own taxes, you can prepare your own will, you can actually cut out your own tonsils. Now, no one does the last one because it's slitting your own throat, but they'll try all the other ones. Why do they think that's okay? Because they think they're saving a buck. I have fixed so many documents that were poorly written, unclear, improperly done, improperly witnessed. It's actually cheaper just to get it done right the first time. I think legal work is a lot like your car transmission. Get it looked at by somebody who knows what they're doing, and it'll run a lot longer, okay? Another impediment is, or another hurdle is, it isn't fun to talk about death and dying. But again, it's going to happen, and I think it's a very freeing thing to know that your ducks are in a row. So the 2 biggest ones, I think, are a fear of the cost and a fear of, if I talk about it, it's going to happen. Look, I've been doing this for 20 years, and I've probably done maybe 100,000 wills in my life. If talking about it means you're going to die, that's just not true because I'm still here, okay? So it's not that hard. Most of the time, a lawyer who does this kind of work, it's usually an initial office conference, gathering some data, gathering some answers, and then it's a second office conference to sign everything. So it's not even that big of a lift. It's easy to do. It should be easy to do. The biggest problem is not doing it.
So to that point, I had that as one of the as a pastor, I hear this sometimes from individuals that I've pastored here, California, where I've been on staff, and other states as well. Particularly younger generation has this. Yeah, what you just said. I already did it online. You know, I used LegalZoom. You guys, come on. I mean, Robert Shapiro or whatever his name was. I'm Ben Shapiro. That's the other TRK, right? So Robert Shapiro was their spokesperson. It's legitimate. Tell us the horror story of somebody saying, I did it online. It's no big deal. I saved money. I don't need to come see you. I did it myself. They either wanted to do it themselves. They thought they'd do it better. They're an aversion to lawyers, whatever it is. Give us the flip side of that.
Okay, I'll give you 2 stories. One, in the last 60 days, these are both within the last 60 days. There was a guy who had a smartphone, and he filmed himself saying what he wanted to happen to his stuff after he died. He was a resident of the state of Montana. He filmed it. He was very clear. It all goes to my brother. I don't want it to go to my ex-girlfriend. I want this to go to this person. Da, 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 da. He went down the whole thing. And then he unfortunately died in a car crash like 2 weeks after he made this video. So when he dies, the brother tries to use the filmed on the phone thing. Everybody agreed that was him and his wishes were clear. The problem is Montana, like Ohio, says a will has to be in writing. okay? And a video is not a writing. So over a period of years, that case went from a probate court to an appeals court to the Montana Supreme Court. And I'm going to guess that family spent tens of thousands of dollars trying to prove this case. And in the end, the Montana Supreme Court said that's not a will in compliance with our laws. It doesn't count. So that guy thought, I'm going to use simple technology. His family spent tens of thousands of dollars and it didn't work. Now, some might say that's a ridiculous result. But understand, in this great country of ours, you own your stuff. If you're dead, you're not here to say, I wanted it to go to Paul or Patty. A document has to be reliable. Reliable means original, signed, dated witnesses. If it's something other than that, it's not going to count. So the technology was there, but the law doesn't provide. In fact, only one state in the United States permits electronic wills, and it's Nevada, okay? Which actually gives me an interesting statistic. Patty told you guys that 30% of Americans have a will. Do you know that 39% of Americans engage in online sports gambling? So that's from a recent study by St. Bonaventure University, February 2024. So more Americans engage in online sports gambling than have a will. That's ridiculous. Okay, so the other story about technology not working, I had a guy lived in Philadelphia. This is a case that I just finished up this past year. He did a LegalZoom will. It was really clear. It said perfectly fine stuff. He signs it. 2 witnesses were involved. That's all that Philadelphia or Pennsylvania required. He dies a resident of Ohio. His brother contacted me, and I have his estate right now. Here's the problem with the dead guy's will. There was a pre-printed date above his signature. It said September 18, 2012. The witnesses, when they signed the date that they witnessed it, September 19, 2012. 1 day later. Guess what? 2 different dates. The law in Ohio says that you had to witness the person signing the same day. So you got a date problem. I was able to convince a court that he did sign it on the 19th and that the pre-printed date was just an oops, okay? But it took a court hearing and witnesses and about $3,000 of attorney fees and subpoena of witnesses from Pennsylvania to get him here. The other problem was the one witness, nice lady, she was a notary, and when she witnessed it, she didn't sign her name. She put her notary stamp on there. Well, the law says that a witness has to affix their signature. Affix means signing. It turned into a big deal, and I had to convince a probate court that her seal was the same action as signing. But again, it took a court hearing. Did the guy want all that to happen? No. Had he signed that in my office, that never would have happened because I have staff and myself that were checking and double checking. Would have saved his family thousands. Technology didn't work.
So I think along those lines, you mentioned it, now you've given stories. There's this idea that it's going to cost so much. If I go see John or anybody else, I mean, thousands of dollars. You know how lawyers are, right? You know, there's this idea. LegalZoom's
They're terrible.
Yeah, LegalZoom's $199, right? So you've given some stories, but help people understand what happens if it's not in writing or it's going to be disputable, the cost of probate versus just having it settled and clear, best of your ability.
Me again, or you?
Yeah, I'm going to let you. Mostly because John's the one that deals with all the probate stuff. The only thing I will say is that you're talking about huge delays, and then and the cost, there's a lot of filing fees with the courts as well as the attorney fees.
And maybe I should just interject and say, maybe I'm not saying this is the case, but maybe there's somebody who's unaware what even when we use the word probate, what does that mean?
Yeah, so I'll tell you what probate is just real quick. Probate is a court process overseen by a probate court. Probate courts across the country are the oldest courts that we have in our country. We haven't had bankruptcy for hundreds of years. We haven't had divorce court for hundreds of years. We have had dead people since the beginning of time. So one of the first courts that was set up in the United States, in every state, was probate court. It's one of the oldest courts. What probate does in Ohio, it's a real limited number of things. Most commonly is they're dealing with property that's in a dead person's name only. So if you have joint ownership, or you do payable on death and transfer on death designations, which is like a beneficiary, or you have it in a trust, that's not in a dead person's name only. So probate wouldn't have to deal with that. But a lot of times, people have a car, a refund check, some account that they forgot to update the designation on it, and then they die. Probate court is the legal process to make paperwork to show who gets it next. If you have a will, the will is the instruction manual that probate's going to follow when you're dead and gone. If you don't have a will, then each state has a law that says where it's going to go. It doesn't just go to the state. Like Ohio says, if you're married and you have children, and if those children are the children of your spouse, it's all going to go to your spouse. The problem is how many steps it takes to get there. And having a will shortens probate up to be the fewest number of steps. So your will helps make probate easier. Probate is dealing with property in a dead person's name only. Probate also deals with when someone becomes incompetent and needs a court-appointed guardian. Probate court deals with adoptions. So if a person's going to adopt a child that's not biologically theirs, probate court deals with that. They do a couple other things too, but they're all just kind of boring stuff. Probate court. It's primarily forms driven. It's paper driven. A lot of people think that if you go through probate, that means you pay taxes. It does not mean that at all. In this state, if you died, there is no such thing as death tax or inheritance tax or estate tax. So if you were the richest person in the world and died as a resident of Ohio, Ohio doesn't take your money when you die. If you live in New York or Pennsylvania, Connecticut, New England states, they would, but not here. So probate's not about taxes, it's more about paperwork and process, and wills help make it easier. Now, to your question, seeing a lawyer, it can be miserable. I'm not going to lie to you. It can be pretty awful. It can be pretty boring. It can be a lot of things. But for estate planning, the person who is the client is in charge. So unlike a divorce attorney or a criminal defense attorney, I can tell you what the result's going to be as an estate planning attorney. The result of your case is going to be what you tell me. If you are in criminal court, it's what the jury or the judge decides. If you're in divorce court, it's what the judge decides. But in probate court, if you've got a will, that will drives the result. So coming to see a lawyer, that's getting peace of mind. It might be a couple $100. I mean, a will at my office usually costs around $200. The same as LegalZoom. And that is done right, and you say what it says. Now, it could be higher than that because you want to do all these ultra complex things, but it doesn't mean expensive. It means done right. And again, that's a stewardship question.
And so it sounds like to some degree, if we're getting wills done, getting clarity about wills, trusts, whatever, it's like 10% of what you're going to lose in or pay out versus probate with, like you said, thousands of dollars in lawyer fees. If a will's $200, and like you just gave illustrations, you've been in, it's $2,000 or $3,000 to get the process along. We're talking 10% of what it would have cost you, right?
I mean, most questions you ask a lawyer, the answer always starts with, well, it depends. Mm-hmm. And that's true, but I think across the board, when you have these documents in place, wills for death time, powers of attorney for lifetime, payable on death, transfer on death for things, you're creating a clear pathway. And I would tell you, it's just like going on vacation. You've only got a limited amount of time on vacation. So you make a plan and you get a map and you get an itinerary so that while you're on vacation, you can make the most of it. Having a will is the map. Having all these documents in good order, like Patty said, that's having an itinerary. So you have as little waste in the process, and more of what you worked hard to accumulate goes to the people you picked, not chewed up in the process. Whether it's 10% or 2%, the goal is have more of what is yours go to who you picked, and that's what these documents are doing.
And then, like you had already done a great job pointing out, the intangible cost of dragging it out and hard decisions.
I was saying, that's the thing I wanted to point out, is the process can be so delayed without having them. And it doesn't go where you want it to go either, in many cases.
Yeah, here's a point. We live in a very mobile society, right? You said California, right? You could be from California and have a lot of family there. So let's say Paul's from California. He's got all of his family in California, and Paul lives here in Ohio. If Paul wanted his brother in California to be his executor after you die, understand that will not happen unless you have a will. Because in the state of Ohio, an out-of-state person cannot be your executor unless you've named them in a document. So as people move around, they're like, that seems ridiculous. We're all part of the same country. Yeah, well, each state has a rule that says they got to live in state if they're going to oversee money. Now you say, why is that? Because some people steal money, and the court has to have enough power to reach out and legally shake them by the neck. That's called personal jurisdiction. So personal jurisdiction says they got to live in state unless you have a will that says they could be executor and live out of state. So if you've got family spread around, you're going to want to have a will. If you've got family spread around, you're going to want to have a power of attorney, because a lot of states, including Ohio, have residency restrictions on who can do that job.
So we have a great question that ties into that. Being close to the base, we have a lot of people who move frequently. So the question came in, for those who move around a lot, is it necessary to update your will if your state of residency changes?
I think the answer to that is it's a little tricky. So anything that's legally done in one state will be recognized in another state. That's what's called the full faith and credit clause. It's in the U.S. Constitution, and it's in each state constitution. So if I did a will in Ohio in 2024, and then my job or my military obligation or whatever relocates me to South Carolina, South Carolina will recognize an Ohio will. You don't have to change it just because you changed addresses. But each state has its own little quirks. So I would at minimum have it looked at by a lawyer in that state. I've had clients who come to see me and they say, hey, I did this will in Michigan. Let's not make any comments about Michigan football, okay? I mean, I don't. That aside, I say, yeah, I guess. I mean, it looks like it's in English. No, I'm kidding. But they've come and I'm like, well, this Michigan will is fine. No changes are required. Now, you would absolutely want to change your will if your wishes have changed. So just moving, I don't think a will, I would get it looked at, but you may not have to change it. Powers of attorney, those are documents that are usable while you're alive. I would absolutely change those. A healthcare power of attorney is designed to be quickly recognized. So Ohio has a Ohio healthcare power of attorney. If I move to Louisiana, they're not going to recognize that very quickly. If it takes more time in a medical setting, that hurts me. So I would do if I was living in a different state, I would do that state's healthcare documents when I got there.
That's great. That's great. Another question came in, trying to get a clarity about, do I need a will? Do I need a trust? Do I need both? What's the difference?
What's the rule about lawyer answers? It depends. Okay. So trusts are a tool in a toolbox, just like a hammer. So if I'm driving nails, I'm going to need a hammer. If I'm making a birthday cake, I don't need a hammer. Person comes to see me and says, I should have a trust. I'm going to ask them why they think that. So if they're worried about, they got minor beneficiaries who, if they died yesterday, they're worried about their 10-year-old kid inheriting. Well, that makes sense to have a trust. Let's say they got a disabled or a disabled beneficiary or someone going through some life issues. Well, trust is a good idea for that. Let's say they own real estate in multiple states. Trust is a good idea for that. But just having a trust because everyone has one, that's not a great idea. Wills work just fine. I think everyone should have a will. And the reason for that is, even if you had a trust, even if you had beneficiaries, understand people die and odds and ends stuff comes up. Personal story, my mom died in 2021. My mom was awesome, great mom, smart, paid attention to things. She worked at Kettering Medical Center. She had blood cancer. She died after like a 5-year blood cancer battle. Well, everything my mom knew that she owned had beneficiaries or joint owners on it. It was easy. And then a year and a half after she died, along came a refund from Anthem, her health insurer. The refund showed up because, believe it or not, health insurance messes things up. And she had been billed for some things that she shouldn't have and paid for some things that she shouldn't have. They had made some mistakes, and so it resulted in a $4,000 refund from Anthem, and it was made payable to her estate. Anything made payable to an estate has to go through probate. Well, thank God she had a will, because her will made probate easy. People say, doesn't probate take a long time? My mom's estate, from start to finish, took 3 hours. Greene County Probate Court and some clear documents, 3 hours. Bing, bang, bong, done. That $4,000 refund check went into my dad's bank account, and it was easy. So even if you have a trust, even if you've done POD, TOD, payable on death, transfer on death, beneficiaries, all that, you should still have a will. Now, if you have issues that you think you should need a trust, go see a qualified professional and discuss it with them.
Can I just add to what you said, John? A lot of times people will establish a trust, but then they talk about funding the trust. So if the assets are not titled to the trust, they still have to go through probate upon person passing. So very important, if you decide to do a trust, that you look at how all your accounts are titled and have them titled to the trust.
Yeah, that's a good point. Trust funding is like putting gas in your car. You know, you could buy an awesome Z06 Corvette, and it looks sweet sitting in the parking lot, but if it doesn't have any gas in it, it's not very fun to drive, okay? So a trust is like that. You could have one, and if you don't put things in it, it's a car without gas.
Give maybe a practical illustration of what you mean by what you just said about
Sure.
the trust and the funding of it.
I'll actually make it be personal because it's very real. So my husband and I both have trusts, and actually when we were in the process of moving from Ohio to Tennessee, we took assets that were in our trust, and we're like, oh, we're going to get a CD. We're going to take advantage of the market for a little bit, and we're just going to set up some CDs. We didn't have the CDs titled to the trust. Actually, we also didn't even have a beneficiary of the trust on those CDs. So that would be an example if we had passed away, or if he had, because they were in his name, if he had passed away, those assets would have had to go through probate in order, and our will says we want everything to be in the trust. So it would just take it from the to being in our names to putting it into the trust.
Yeah, so for an example, a real simple thing, funding is the name of the trust appears as the owner of the bank account or the house or the car, or the trust is named to be the beneficiary of the bank account, investment account, whatever it might be. So I have a checking account at Fifth Third Bank. If you look at the checking account, the actual checks, it says my name and my wife's name. That's not in a trust, it's in our names. But we have what's called a payable on death on there, so if we're both dead, it would seamlessly kick into that trust, and that's funding.
Got you. Let me throw, somebody said a question that they know has become more and more pertinent as home structures change. They said, if hypothetically you have a child on your bank account, that child and his spouse get divorced, is that account at risk in a divorce settlement?
Yes. Yeah. So this is a huge problem. I work with a lot of banks. I've sat in many banks, and I'm not making fun of any one bank or another, but I'll hear bank personnel say, oh, you don't want to go through probate. Let's go ahead and add your son or daughter as a joint owner on your account, because if you became incapacitated, they'd be able to keep paying your bills. That's true. They also say, and if you died, it'll help it avoid probate. Well, that's true too. But what they don't say is, yeah, and if you're not incapacitated and your child decides they want to take everything you have and blow it on wine, women, and song, they can do that too. All right? If they get sued for texting while driving, that lawsuit, if I'm a lawyer representing someone who got injured in that crash, I'm coming after everything they own. Oh, you have a half interest in mom and dad's $500,000 investment account? That sounds like a tasty target for a lawyer to go after in a lawsuit. Divorce proceeding, bankruptcy, all of that is fair game. So I stood in a church in 2001 and said some vows and married my wife. That's about the only person I'm willing to take a risk on in this world. Everybody else doesn't need to be a joint owner on my account, okay? And I have seen stories where it worked out well, but I can tell you a bajillion horror stories where it didn't. So a safer solution is, instead of naming a joint owner on your account, name that same person as a power of attorney. So if you became incapacitated, they could use that document to access your property for you, not for themselves. Because if a power of attorney got sued or divorced or bankrupt, that lawsuit, bankruptcy, or divorce doesn't reach into your stuff like joint ownership would.
Got you. Another question that came in: what happens when beneficiaries have passed away? If the person put them down passes, incapacitated in some way, and their beneficiaries have passed away, either dated or tragedy is on tragedy, they're in the same situation of tragedy. What happens with those?
Great question. So, payable on death, transfer on death, that's a way to name a beneficiary. The idea of it, though, is it's quick and immediate. So, person names a beneficiary. Let's say they got 3 kids, Huey, Louie, and Dewey, and they think, oh, I'll name Huey, Louie, and Dewey because when I die, it'll go to them real quick and easy. And then Louie dies. Well, in the fine print, it's going to say in the beneficiary designation, the beneficiary only inherits if they outlive the property owner. So if Huey, Louie, and Dewey are listed on there and Louie dies, that went from going a third, a third, a third to 50-50 between Huey and Dewey. Louie's out. Louie's family is out, okay? And it happens immediately. You say, well, that's not what I wanted. My will says if Huey, Louie, or Dewey is deceased, then Huey's kids get his part, and Dewey's kids get his part, and Louie's kids get his part. Yeah, but remember, the beneficiary designation bypasses the will, so none of that stuff applies, okay? Another problem with beneficiary designations, for example, my wife and I have a 15-and-a-half-year-old son. Love my son, great kid. He's responsible for a 15-and-a-half-year-old. But legally, he can't own stuff until he's 18. So if my wife and I named him as a beneficiary and we died yesterday, guess what? It avoided probate when we died going to him, but now it's back in probate because he needs a court-appointed guardian to help get him to oversee that property until he's 18 years old. That's an oops or a fail. So you got to be real careful with beneficiary designations that you understand who you name has to outlive you to inherit, and if they don't, it's not going to descend down unless you state it that way. If it does descend down and it goes to minors, it's going to go through probate. So these are all complications that happen from one simple thing.
That LegalZoom will walk you through, though, right?
Oh, yeah. They're really great about that. That's right.
Right.
So John, I wanted to clarify, though. Let's say there was only one beneficiary named, and that beneficiary is the one that passes away. That puts it back into the probate. Is that correct?
Well, maybe. It depends. No. So you name one beneficiary. That beneficiary dies before the account owner. one of two things is going to happen. Either it then goes to probate because there's no beneficiary, but there are some places, life insurance does this, some workplace pension benefits do this. They have a built-in default rule of who gets it next. So it could say, if there's no beneficiary, it pays to next of kin, family. Now, a bank account wouldn't do that, but like life insurance will do that sometimes. Pension, stuff like that, or not pension, but a retirement. So naming a beneficiary is always clearer. If you want it to go through your will, say, pay it to my estate if there's no living beneficiary, because that way then it will go to the will.
And the only thing I want to add to that is that's why it's so important to revisit beneficiaries too. So, you don't just put them on there once, and especially if there's a change of marital status.
I have that case right now. A guy, he's a client of mine, Larry, great guy. He had an unexpected death where he was going in for heart surgery. It was routine, and he died 2 days later. Terrible for him and his family. But sadly, he's got a retirement account that had a listed beneficiary. The problem is that beneficiary was his wife 2 wives ago. So the payer's like, we're not paying anything until we have a real clear instruction about what ex-wife, and she's a nice lady, by the way, but it's confusing. So it would have been all far simpler if he just would have updated his beneficiary designation.
Maybe a final thing, we'll open it up. I'm dealing with this in a more as a friend capacity to somebody. A family member, thinking they were doing a good thing, named all the children as executors in the estate. Yeah, that's exactly what's going on. Yeah, give some advice about. I know you said a little bit already about appointing power of attorney, durable power, all that. What's your advice about how many? Who? You already said some of that. Maybe anything you want to add to that to avoid some well-meaning well, all the kids should have a say in this. You really shouldn't, though, right? So,
I'll say it real easy like this. Let's say Pastor Paul and 10 other people were all the teaching pastors here, and they all spoke at the exact same time with their own message. This place would be mayhem, right? Having 2, 3, 4, more than one executor, it's legal. It's just not wise. Now, as I talk to clients about it, I say, what are you really worried about? Are you worried about somebody taking over and lording over everyone and keeping all the information to themselves and nobody knows what's going on? And most of the time, clients are like, yeah, that's exactly what I'm worried about. They're not a good teammate. They don't communicate well. Well, that's a perfectly valid reason. So I put stuff in the document that talks about mandatory communication, right? You're going to at least report quarterly on what you're doing. So every 3 months, here's copies of bank statements while we're working through mom or dad's estate. But having multiple executors, huge mistake, because while the estate is open, guess what? You got to pay an electric bill. Well, if they're co-executors, that means the bank requires every one of them to sign the check to AES for the electric bill. Or they all have to agree upon the realtor when they sell the house. They all have to agree upon the sales price for the car. And you know what? They might most of the time, but at some point they're going to disagree, and then it gets nuts. And you know what courts often do? They resolve controversies between people who can't get along. So the idea is reduce court. You want to reduce court time? Name one person at a time.
And I was just going to say exactly what you said, John, was have them be successors, but you don't have that at the same time. So you can have more than one in there, but they're successor if the first one isn't able to.
Yeah.
It's a lot like a football team. There's a starting quarterback, and if they're not available, then we got a backup quarterback, and if they're not available, we got a third string quarterback. That's exactly what executor and power of attorney should be like.
Have you thought about giving the Browns that advice yet?
How did you know that I'm a Browns fan? Good news is Deshaun Watson hurt his Achilles again, so he may not ever take another snap for the Browns ever. This is great news.
You get the guarantee money. Oh, my goodness, right. So let me do this. Let me grab, in case there are a few questions. If I could have 2 people come up to help run these around real quick. Okay, who? All right, Tyler, thanks. Dustin, appreciate it.
Thanks for everybody's time today. I'm
Yep.
sure it's boring and stuff, but hey, it's free legal advice, so there you go.
Well, and it may be, dry, boring, or like monotonous, but when it matters, it's not. And I mean, you all are at the intersection, have been much more than me, but I end up at that intersection regularly, and it's complex and frustrated people in a hard, grieving time, and it adds and compounds. It doesn't help, smooth things out. So let's take it. If you have a question, and I get you made like, I don't want to spill all my beans here. That's fine. A friend of yours. So if you have a question real quick for either one or both, throw your hand up real quick so we can get to you. So if you've got that, throw your hand up and we'll run it to you.
If I have a house and I sell the house, do I need to update my will because of that? Because something is gone, or does it just disappear? Or if I own the house, sold the house, and bought a house in a different state, should I update the will?
It depends. No, so let's pretend that your will said, my house at 1234 North Main Street goes to my friend Pete, okay? And then you sell 1234 North Main Street and you buy 567 2nd Street. Then I would absolutely change the will, because the question is that instruction so specific that it applied only to the Main Street house, or does it also apply to any other future house, okay? Now, most wills do not say those kind of provisions. Usually they say, anything I own, whatever it is, wherever it is, I leave to my friend Pete. You don't need to update your documents just because you changed addresses, unless you've got something specific like that in there. Make sense?
Good question. Other question.
I have two questions. What happens to the original will if your lawyer dies? Is that at the state, or is that in his office in the basement? And second question is, if I had a will done, let's say 10, 15 years ago, should I update it?
Okay, I'm going to take them in reverse order.
There's no changes.
Oh, so just the passage of time. If your will is designed to last and last, it's a durable document, okay? So if you've had no changes, a 10-year-old will is as legal now as it was when you signed it, okay? But you want to make sure you know where the original is. So let's pretend it's at the lawyer's office and the lawyer died. It's true, lawyers are people too. So what happens to that will? Well, I would want to pinpoint where is the original. So if that lawyer was part of a law firm and it still exists, odds are that firm still has the original will. But I would want to confirm that. If I was you, I'd confirm that. Let's say they were a small office or a solo lawyer. It's hard to say where it went. This is a huge problem in states like Ohio. The Ohio Supreme Court does not have a standard rule for what happens when a lawyer dies with original documents like a will. Lawyers are supposed to plan for that. I have. So there's multiple lawyers in my office. So if I died yesterday, one of them has access to our safes just like I do. And I've got staff, and they have access to the safes. If they're all dead, I've even got lawyers outside of my firm named in my documents who could help my clients get their original documents. Plus, we have instructions to the client that says, we will hold your original until you tell us otherwise. So that's where I would encourage you to reach out. And if you can find where that lawyer, either what happened to their stuff, A lot of times the local bar association knows that. Every week I get an email from the Dayton Bar Association saying, lawyer so-and-so is looking for an original will signed by dead guy Smith. Does anybody have any idea? And it was done by lawyer Pete Jones. Does anybody know what happened to Pete Jones's documents? And does this name sound familiar? So I search my whole big inventory of wills, and if it's on there, I respond back. So it's kind of a seek and find. Now, if you don't get any confirmation of where the original will is, you should absolutely do a new one, because the original will, not a copy, not a scan, the ink on paper original is the one that matters when someone dies.
Very good. Thank you. See another hand right here. Do we have a microphone? My mother, so answer very judiciously. Or favorably.
She says, say I want to disinherit my...
There's two of us, so we'll find out.
For my education, is probate an absolute, or do you do things do you want to avoid probate, or is probate just part of the process?
So it's not an absolute. Basically, it pops up if there's something that needs to be dealt with that doesn't have a joint owner, doesn't have a beneficiary. So it's entirely possible that a person could die and none of their stuff goes through probate, and that's fine. But probate's not a punishment either. I often use the word, it's a cleanup filter, right? So if, like with my mom, everything she knew she had probate avoiding joint owner or beneficiary. Well, that was awesome. So that stuff was pretty easy to handle. And then when that refund popped up 18 months later, probate ended up being a cleanup filter to deal with just that one thing. It took 3 hours. It was no big deal. So it's just a different way to handle something.
Yes, one back there.
Should you file your will with your county? Like, say I have a will, and should I take it to Montgomery County just in case the lawyer dies or something like that?
You can. There's a process in Ohio where you can file your will with the probate court where you live while you are living. I don't really recommend it. The reason is it costs money to put it in there, and it also costs money to get it out of there. And if you moved, you have to remember that it was at Montgomery County, Ohio, and let's say you live in Montgomery County, Maryland, which there is one. Your family would have to then get Montgomery County, Ohio probate court to release it to Montgomery County, Maryland probate court. And I've been through that process, and it's real clunky and not very easy to do. So in my opinion, there's 4 places you could keep your original will. One is at home, like in a lockbox at home. One is with the lawyer that prepared it. One is with a safe deposit box at a bank. And the 4th one is with a court like you're talking about. Of those 4, the bank and the court are not a good idea because they're real clunky, cumbersome, cost money, and they have a lot of rules, none of which make it easy for your family. With you or with the lawyer is better, but you really want to make sure you understand if the lawyer died or sold their practice, what happens. And if it's in your home, you want to make sure you don't write on it, lose it, file it with stuff that, don't put it with the Papa John's paperwork that came in the mail yesterday, because that's going to get thrown out. I have clients who say, I've got a fireproof safe. Fireproof is great. Problem is houses flood. I had a guy who had a fireproof safe, and it was on the basement floor of his house. And a water main broke in Kettering 2 years ago, and there was 2 feet of water in his basement. His fireproof safe didn't do a great job of keeping his will waterproof. So just be careful if you keep it at home. Make sure the important people know where to find that document. Patty said that during her presentation.
The only thing I'll add to what John said, though, is like I know for myself, we have our fireproof safe. I've put it inside something that addresses the issue with water. So I put it inside something that was plastic for exactly that reason.
Think about how much money Ziploc could make if they made a will-sized baggie, right?
It's a hoot. Anybody else? We're down to our last one or two. Right here.
Just say me and my wife pass away together. Is my kids financially responsible to pay any debt off?
Great question. So I'll try and hopefully this will be a clear answer. The general answer is no, and I'm going to speak specifically to the state of Ohio. Every state is different, but in the state of Ohio, Ohio's laws are very friendly, I think, to families and people. The way it works in Ohio is when someone dies, anyone to whom they owe money, a creditor, has an obligation to come forward with that claim, and they have to do so in the first 6 months after the person died. And the only way they can come forward is by filing that claim in a probate court. If they don't do both of those things, most creditors don't get paid anything. So if a person died June the 1st of 2024, married, unmarried, doesn't matter, and they had a $10,000 medical bill that was due to Miami Valley Hospital. And then today, what is today? January 11th? Is that 12th? Excuse me. January 12th. So tomorrow, because tomorrow's a business day, January 13th, their estate gets open in probate, and Miami Valley Hospital files a claim to get paid on that medical bill. It does not get paid by the estate or anyone in the family because they died June the 1st. 6 months after was December the 1st. Probate wasn't open until January the 13th. Miami Valley doesn't get paid by anyone, okay? Not the spouse, not the kids, not anyone. Now, if the estate had been open July the 1st, Miami Valley did the same thing. They would have to get paid by the property that passes through probate. And if there wasn't enough money to pay that medical bill, they could go after the spouse, but not the children. Okay, so in Ohio, the law is a spouse is obligated on medical bills and anything that's called a necessary, like final illness and stuff like that, but only if the creditor filed their claim in the first 6 months in probate. Anything other than that, the only ones who have superpower rights to get paid after someone dies are the federal government for tax claims. It's the golden rule, by the way. They make the gold, so they make the rules. That's the IRS. State of Ohio Department of Taxation has some special rules. Medicaid has some special rules. And any debt of record, like a mortgage or a car loan, has some special rules. Everything else doesn't get paid.
All right, final two. I think I saw Miranda and Trina. No, never mind. I didn't see a hand. My bad. Trina, congratulations.
So say my husband and I both passed and we've named our kids to somebody that's not family. And is that something that would go through probate? Is there paths that you take with that? And can family fight that if they're not who's listed?
So you're saying, like, who's going to raise those kids? Is that what you're asking?
Yeah, as minors.
Yeah, so again, I'm going to speak to Ohio law because that's what I know about, not other states. But so for minors, people under 18 or who have a disability, dependents we'll call them, if their custodian parent dies, then a will is where you can name who would be their next guardian to raise them to 18, or for a disabled person to take care of them even past that. So if you name that in a will, a court is going to have to appoint that guardian. Okay, it doesn't avoid probate, which makes sense when you think about it, because that guardian's going to need some paperwork to connect them to that child when they go to get medical care at the hospital or a pediatrician. It also is paperwork they're going to need to enroll that kid in school and do all kinds of important things. So if you're a parent of a minor, you're going to want to have a will so you can designate who's going to be their guardian. You can name whoever you want. And if you name someone who's not a family member, the court's going to appoint that person you appointed. Can a person fight that? Sadly, yes. I mean, this is the United States of America. Anybody can sue for anything. Courts are supposed to be accessible. But the real question is, will they win? And the answer is generally no, because there's a code section of Ohio law that says a court needs to appoint a suitable guardian, and if you name that people in a will, they're supposed to be given a leg up above everybody else. And it doesn't matter if they're relatives or not. So, speaking personal, my wife and I, we've redone our wills a couple times. So our son is 15 and a half. When he was born, we named who we wanted to be guardian if we both died, okay? Well, at age 2.5, our son was diagnosed with type 1 diabetes. It happened. We didn't know anything about it. Neither of us are diabetics, but he is. So that changed who could care for him, because you got to get up in the middle of the night and do stuff, and it's a lot of work. So we changed our wills to reflect wishes. And then he was 2.5, and then some of those people we named moved away, and now that he's been in school longer in Beaver Creek, it's more important to us that he be local to finish up his high school thing. So we've changed our wills to keep it current, and we haven't named any family members. It's all non-relatives. Of course, you pick your friends, you're giving your relatives. So, no, I'm kidding. That's just but you can name whoever you want. A probate court will be involved, but a will makes that easier. Okay, that's why you want to keep it current. And like Patty said, I think you should name backups. People ask me all the time, what if the people I named can't do it? What if I named my cousin and he gets a terrible disease? He may not be even able to be the guardian for my kid. So you want to name backups so that the person has an option to say, I can't do it, or pass the torch to the next person. I think that's important to do.
Any closing final thoughts? I know we've kept you guys, and I really, really appreciate it. Such an important and complex matter. You've made it a lot more accessible. Any final thoughts you'd say, young, old alike? What would you say to us?
Get your documents in place. Have your wishes be documented so they can be honored.
Again, I just would reiterate the stewardship part. God entrusts us with lots of gifts and talents and abilities. Sometimes he even entrusts us with money and things. Money and things are not sin. It's the love of money and the love of things that's sin. So if you've been entrusted with things, you've also been entrusted with the responsibility to be a steward of them. So I think it's important to, change the oil in your car, keep your passwords safe, but also to do documents like wills and powers of attorney, because that's what stewardship looks like.
Wonderful. Thanks so much. Let them know you appreciate them giving us some time today. And if I could ask you all to go to the foyer, there may be somebody who either has a question or wants to set up an appointment. Again, they were glad to do this. This is not to generate, obviously, leads and revenue. This is us trying to connect with experts who are willing to give of their time to help us. So if you all go to the foyer, and if you need anything, let us know and let them know how you can be helped.
There were the 2 documents that we copied for this section. That people can just pick them up, I guess, when they go out.
They got handed out from what I know during the break, but there are documents for this section. If it didn't get handed out, they're in the foyer. All the documents from morning, from the first and second, should be out there. Grab those and be helped.
All right, very good.
I'll have
Thank
you all
you.
go out. Thanks so much.
Thank you guys for your participation.
Yeah, glad to.
Thank you.
Yeah, glad to. I'll take that from you. Yeah. Want to say, if you're able to join us tonight at 6 o'clock, we start our new series. Tonight's kind of the foundational, important, pivotal message, young or old. When we start talking about 21st century help from God for today, tonight is the foundational, pivotal message. If we can't embrace this, really, there's nothing else going to help you in the series. I mean, I can't stress that enough. And so I want to encourage you, if you're physically able, be here with us 6 o'clock. Have your young folks here as well, so you can be help to encourage and also build a thought process and a biblical mindset about God, His Word, His help for us at a very daily level. All that said, I would ask you to continue praying for the Millers, continue praying for the Bonamas as well. And I hope you enjoy what looks like a cold but sunny afternoon. So we'll see you tonight.